California exam prep, property ownership, and land use controls and regulations. You can expect 15% of the exam to be on this topic. Classes of property. Land. The Earth's surface extending downward to the center of the Earth and upward to infinity, including permanently attached natural objects. Real estate. Land plus all the things permanently attached to it, naturally or artificially. Real property. Real estate plus the interests, benefits, and rights included with real estate ownership. It's helpful to remember that land is less than real estate, which is less than real property. Real property is the land, the real estate, all of it. And that kind of goes with the alphabet. So L comes before RE, which comes before RP. That's how I remember it. Improvements. Artificial attachments to land that include things like fences, buildings, and walkways. Personal property. Everything owned that isn't real property. 5 basic tests can help determine if an item is real or personal property. MARIA. MARIA stands for the method of annexation, which refers to whether or not an item is attached to property and how permanent that attachment is. Adaptability for use refers to how an item is adapted to real property. If removing an item would change or eliminate the use of the property, it's likely real property. Relationship of the parties. In general, the courts tend to favor a tenant's take on an item over the landlord's, and a buyer's over the seller's. Intention in placing. If an item was intended to be temporary, then it's less likely to be considered real property. Agreement of the parties. The simplest and first test is whether the parties have agreed an item will stay or go. Quick pause. If this is helpful, tap subscribe so you can find this later when you're cramming. Okay, back to it. Fixture. Anything permanently attached to the land or to permanent structures on the land. Fixtures are part of real property and are conveyed with the sale of the property unless the parties negotiate differently. Fixtures that are removed from the improvement before an agreement of sale becomes personal property again through the process of severance. Annexation. This is the process of converting personal property to real property. Trade fixture. Anything that's attached to leased land or structures and is used in conducting business. So a pizza oven for a restaurant that serves pizza. Rights and responsibilities differ depending on the commercial lease agreement, but usually tenants may remove trade fixtures when the lease terminates, though they must repair any damage created by removing the fixtures. Trade fixture, pizza oven. Real property is commonly categorized according to its use: residential, single-family or multifamily dwellings, commercial, income-producing properties, retail stores, restaurants, offices, hotels, industrial, warehouses, factories, agricultural, farms, ranches, timberland, etc. Special purpose, hospitals, churches, schools. Property characteristics. Physical characteristics of land. Immobility. The geographic location of land is fixed and can't be changed. That's why it's always location, 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 because you cannot change that. Indestructibility. Improvements may deteriorate over time, but the land itself will not. Uniqueness, non-homogeneity. One piece of land is never exactly like another. Economic characteristics of land. Scarcity. You can't make more of it. The land we have now is the land we'll always have. Improvements. A land's value can be positively or negatively affected by the improvements placed on it. Permanence of investment. Some improvements are long-term, stable investments with stable returns over time. Situs, location, area preference. A property's value depends in large part on its location. The spots next to the beach, for example, are almost always going to be a little more valuable than the houses across the street, not right next to the beach. Encumbrances. Encumbrance may be financial or physical. It limits the owner's use of property and can affect marketability and value. For example, liens are a form of financial encumbrance, while easements and encroachments are physical encumbrances. The property's deed and title history should list known easements. Subdivision maps maintained by county recorders' offices may show known easements that exist on lots and parcels. An on-site land survey can help determine easements, encroachments, and lot size. Liens. A lien is a creditor's legal claim to the property of a debtor. It prevents the debtor from transferring the property until the debt has been repaid. It may allow the creditor to sell the property through a court sale, foreclosure, and be repaid from the proceeds of the sale. A lis pendens is notification to the public that a legal action, such as a lien, is pending and could impact title to a property. A lien can trigger a foreclosure if the property transfers to a new owner and the lien remains unpaid. Lis pendens, pending. General liens affect real and personal property and include judgment liens, federal and state tax liens, and decedents' debts. Specific liens affect the specific real property to which they're attached by agreement of law. These include mortgage liens, real property tax liens, mechanics liens, special assessment liens, vendor and vendee liens, and HOA liens. A general lien affects everything in general, is how I like to remember it. It affects real and personal. It affects the whole dang deal. Everything. Specific only affects specific. Another way to classify liens is as involuntary or voluntary. An involuntary lien is one created without the property owner's consent, like a property tax lien. A mortgage lien, because the property owner chose to enter into a mortgage, is voluntary. A mechanics lien is one a vendor of goods or services places on the property. A statutory lien is created by law. It's an involuntary lien created without any action required by the property owner. An example would be property taxes, of course. An equitable lien is created by a court of common law. It does not give right of possession, but it does encumber the property. Real quick, here's how I remember the liens. A mechanic's lien. If you didn't pay the mechanic for the work he did on your car, he can place a lien on you and your property. A statutory lien is created by law. It has to do with state laws, statutory state law, taxes. Equitable lien, court of common law. California has a homestead exemption, which prohibits a creditor from forcing the sale of the owner-occupied home to repay a debt. It also allows a homeowner to protect a certain amount of equity from creditors if the home is transferred. In general, the date the lien is recorded determines the order of priority when paying debts from the sale of a foreclosed property. The lien that is first to record is paid first because it was recorded first. However, certain types of liens, such as property tax liens, take priority over other liens regardless of the date of recording. In other words, certain liens get to skip the line. In California, tax liens and special assessments take priority over other liens. Assuming the mortgage deed of trust is the senior lien and is next in line, that's paid next. Then the homestead exemption is taken out. After that, the levying authority is reimbursed, and then all others are paid in order of recording. Easements and licenses. An easement is a non-possessory right acquired by one party to use another party's land for a special use. These are often acquired through written agreement. The dominant estate. The property or individual who uses the easement holds the dominant estate. It's said that the dominant estate enjoys the easement. The property on which the easement lies is the servient estate. It's said that the servient estate suffers the easement. It's serving the other estate. The property deed and title history should list known easements. Plat maps may also show easements. Categories of easements include easement appurtenant, attached to a specific parcel of land, which transfers or runs with the land, and gives the dominant tenement rights to use adjoining property or the servient tenement. Easement in gross, granted to a specific individual or entity rather than attached to the property itself. Easement by necessity. This easement type can only be created for the purpose of ingress and egress. Easement by prescription. This easement isn't legal and is created through continued, uninterrupted, obvious, exclusive, and adverse use of someone's property without permission. An easement can be created by express grant or express reservation in a grant deed. The grantor determines the dominant and servient interest. Implication of law. The circumstances and conduct of the parties creates the easement. Since any parcel of land must be allowed access, this is usually how an easement by necessity is created. Condemnation. This is when the government exercises its right of eminent domain to take a portion of private property to create roads or sidewalks. By contract. This is an agreement reached between the parties that isn't part of the deed itself. An easement may be terminated by express agreement, merger of the dominant and servient tenements, abandonment, destruction, lawsuit, adverse possession, excessive use, allowing legal termination, estoppel. A license is temporary permission for one person at the discretion of the property owner to do something on another's land without actually possessing any interest or ownership in the land. A license is not assignable or inheritable. Encroachments. Encroachments are structures or objects built on another's land without permission. Encroachments are always, by definition, illegal. A survey establishes the boundary lines of a property and may help identify both encroachments and easements. Types of ownership: freehold and leasehold estates. A freehold estate is an interest in real property where the owner's possession of the property isn't of a fixed duration, as it would be in a leasehold estate. Fee simple estate, aka fee simple absolute, is a type of freehold estate that conveys the most rights available. Property held as a fee simple can be sold and is inheritable. Fee simple estates may be limited by both public and private restrictions, such as zoning ordinances or restrictive covenants. The owner holds rights to the property on the surface of the land, above the land, and below the land, unless those rights have been separated from the property and conveyed to a different owner. Fee simple estates must pass through the probate process before legal distribution to heirs. Survivorship and inherited rights vary according to state and local laws and by how the title is held. Fee simple defeasible is a type of freehold estate in which ownership is subject to either occurrence or non-occurrence of a particular event. The two categories of fee simple defeasible estates are fee simple determinable and fee simple subject to condition subsequent. With a fee simple determinable estate, the current property owner conveys ownership to a new owner as long as some event does or doesn't occur. For example, Tommy Tom gives a plot of land to a local parks district as long as the district only uses it for a community garden. Go Tommy Tom. He gives the possibility of reverter to his son, Jojo Joe, someone named by Jojo Joe, or Jojo Joe's heirs. If the parks district changes the property's use, the estate automatically ends, and the property reverts to whoever holds possibility of reverter. In this case, Jojo Joe, someone named by Jojo Joe, or Jojo Joe's heirs. With a fee simple subject to conditions subsequent estate, the current property owner conveys ownership to a new owner on a specific condition. For example, Marta conveys her home to her son, Rickon, on the condition that the property remain residential. If Rickon converts the property to some other use, like a bowling alley, the estate doesn't automatically revert to the original owner, but Marta, or Marta's other heirs, successors, have the right to reacquire full ownership, but they'll have to go to court to do so. What can I say? Marta does not support bowling, so... A life estate is a type of freehold estate in which ownership is limited to someone's lifetime. The future owner is determined based on the life estate's terms. An ordinary life estate is based on the life of the estate holder life tenant. For example, Kristanicia gives her son TT a property for his life. TT gets to use and live on the property as long as he's alive. When he passes away, the property automatically goes back to ding ding ding, Kristanicia, or whoever holds the remainder interest. Pure autre vie is an estate based on the life of someone other than the life tenant holder of the life estate. If Kristanicia gives TT a property for the life of Philip, TT gets to use and live on the property only while Philip is alive. When Philip dies, the property will go back to Kristanicia, or whoever holds the remainder interest. During the term of a life estate, the estate holder must keep the property in good repair. Any act by the estate holder that significantly reduces the value of the property at the end of the life estate is called an act of waste. The estate holder or another party with interest in the property, for example, heirs to the estate holder, may file a lawsuit to stop the waste and/or seek damages. When a life estate ends, ownership of and interest in the property is determined in one of two ways. Remainder: ownership will pass to a remainderman instead of the party who established the life estate. Reversion. Ownership will revert to the life estate originator or the originator's successors or heirs. When a life estate ends, the remainderman or reversion holder holds the estate in fee simple. A leasehold estate is an estate in which the holder has a possessory interest in a property but no ownership. Types of leasehold estates include: an estate for years is a lease that ends on a specific date and must be renewed by mutual agreement between the landlord and tenant, aka chattel royale. In California, an estate for years is known as a periodic estate, so it's an estate from period to period. A periodic estate is a lease that automatically renews at the end of its term, such as a month-to-month lease. An estate at will is a lease without an established ending that can be terminated by either party. An estate at sufferance is one in which a tenant, referred to as a holdover tenant, didn't leave when the lease expired. In California, a long-term lease is 6 months or more. A short-term lease is less than 6 months. Bundle of rights refers to the rights extended to a property owner to use the physical components of land, such as the surface, subsurface, and air rights. The bundle of rights includes possession, the right to occupy the property and recognition as holder of the title. Control, the right to use the property, build on it, or grant an interest in the property to others, provided that interest is within the law and any community regulations. Exclusion, the right to decide who may or may not access the property. Enjoyment, the right to use the property legally without harassment or interference. Disposition, the right to sell or convey the property. When purchasing property, the buyer may or may not receive all the property rights in the bundle of rights. For example, the property may be leased to someone else, thus denying the owner all of the rights. The mineral, air, or water rights may have been split off or sold separately. Mineral rights, also known as subsurface rights, are the rights to drill or dig for minerals on the property. Air rights refer to the right to use the area in the sky above a property. Okay, believe it or not, we've actually covered title, so go check out those videos if you want to review, but here's just a super quick brush up and why title even matters while we're going over land use. So here's how that ties in. Ready? Let's go. Joint tenancy includes the right of survivorship, which means that the surviving co-owners own the property of a joint tenant who dies. If there are only 2 joint tenants, the death of one dissolves the joint tenancy. The remaining tenant becomes the owner of an estate in severalty. If there are more than 2 joint tenants, a deceased tenant's ownership transfers in equal parts to the remaining joint owners. When a joint tenant sells interest in a property, the buyer doesn't become a joint tenant with the other owners. The buyer is a tenant in common with the remaining joint owners. That's because the unities of time and possession don't apply. This is super important, this concept. There will absolutely be a question on your exam about this. Tenancy by the entirety. California doesn't recognize tenancy by the entirety, but some states do use this form of ownership. It requires the 4 unities of joint tenancy, plus a 5th unity called unity of person. This refers to married couples as one legal entity, so this form of ownership may only be used by married couples. Some states extend this right to domestic partnerships and civil unions. Co-owners have the right of survivorship. If one dies, the other becomes the sole owner of the property. Since tenancy by the entirety is inherently based on the owners being married, in the event of divorce, both parties automatically become tenants in common. If the ex-spouses don't want to co-own the property, each is free to sell their individual interests. Tenancies by the entirety are not allowed to convey a fractional interest in the property. Transferring the property requires both parties' consent. Community property. California is a community property state. In general, property purchased during a couple's marriage or domestic partnership becomes community property. Each spouse or partner has an equal ownership share in the property. Property owned by either spouse, partner, prior to the marriage is considered separate property unless it's converted to community property by an agreement between the spouses. Property acquired during the marriage partnership by one individual by inheritance or gift remains separate property. Income generated by separate property remains separate property. Income generated by wages earned during the marriage or from community property is community property. The spouses, domestic partners may agree in writing to hold property as separate property rather than community property. When real estate is purchased in California by a married couple or domestic partners, the deed may specify that the title is held as community property or as community property with the right of survivorship. If the right of survivorship isn't specified, a spouse or partner's half interest in the community property can be willed away from the surviving spouse or partner. When the right to survivorship is specified, the property automatically becomes owned in severalty by the surviving spouse. Both co-owners must consent to a transfer of the property. A lien may be placed on the community property due to unpaid debt of an individual co-owner. That is land use. You made it to the end. Subscribe and come back to study again tomorrow. Your next topic is right here. Click it and keep going.